Hi folks, how you going? I'm Carolyn Ryder from Ryder Lawyers. I'm a lawyer who works in estate law here in Queensland. And today I wanted to talk to you about something that comes up in conversations, contesting a will. So it can be a complex and emotionally charged process, but I'm here to break it down for you. So what does contesting a will actually mean, and how can it be done in Queensland? Let's dive in. So first things first, let's talk about when someone might want to actually contest a will. Essentially, contesting a will means that you're challenging the validity of the will, either because you believe it doesn't truly represent the deceased's wishes, or because you think it's unfair and it doesn't provide for you adequately. But before you jump to any conclusions, it's important to understand that not just anybody can contest a will, and there are specific grounds to do so here in Queensland. So in Queensland, the most common grounds for contesting a will are, number one, that the deceased person lacked what we call testamentary capacity. So what this means is that the person who made the will didn't fully understand what they were doing. Maybe it's because they were suffering from a condition like dementia, or they had some other like mental illness that impaired their ability at the time to make sound decisions. The second reason that a person might contest a will is because they think the person who made the will was unduly influenced. So this is when somebody pressures or coerces the person into making a will to either include or exclude people or certain assets in the will. So this can be a really tricky one to prove, as you need strong evidence that the undue influence was present. The third reason that a will might be contested is because it lacks the proper formalities for a will. So here we talk about, did the will meet all of the legal requirements for a will in Queensland? For example, here in Queensland, a will has to be signed by the testator, the person making the will, and witnessed by two independent witnesses. If those requirements aren't met, in some circumstances, the will might not be valid. The fourth reason that a will might be contested is because it doesn't make proper provision for the deceased person's dependents. So this is the type of claim that can be brought under the piece of legislation governing claims like this called the Succession Act of 1981. So this is where you argue that the will didn't make adequate provision for you as an eligible person, and you might be an eligible spouse of the person who's passed away, their child, or their financial dependent. So now let's talk about timing. If you're considering contesting a will, it's crucial that you act promptly. So in Queensland, there is a limitation period that applies. So firstly, you have to notify the executor within 6 months of the person passing away that you intend to contest the will. Then you have to file your application within 9 months from the date of death. If you miss those deadlines, you might not be able to contest the will at all, unless you have a really compelling reason for the court as to why you delayed. So of course, contesting a will can be really complicated, and it's an emotional process. You're grieving and having to consider your legal rights. So it's always best to speak to an experienced lawyer who can guide you through the process. Lawyers like me can help you to understand your rights, gather the evidence that you need, and give you a realistic idea of your chances of success. So today I'm wondering, have you or someone that you know ever considered contesting a will? Or do you have questions about what this process involves? I'd love to hear from you. You can leave a comment below or reach out to us at our office address if you want to discuss your own questions further. Thanks for watching, and remember, when it comes to estate matters, it's always best to be informed. Thanks for watching. Hope to see you again soon. Bye.